SJC-10316 Lobisser Building Corporation versus Sutherland.
May it please the Court, Your Honors. Thomas Moriarty for the plaintiffs in this matter, Lobisser Building Corporation and Crystal Springs Condominium Association, Incorporated. Crystal Springs is a phased condominium located in Bellingham, Massachusetts, presently consisting of 41 residential townhouse units. Well, that may be a loaded term in this case, Your Honor, but by that I mean that the original declarant of the condominium reserved the right to build and submit additional units to the condominium in subsequent phases. It is the plaintiff's position, obviously, in this case, that the land court's judgment constitutes...
Let me just ask you, this may be a very simple question. Can you simply apply for a new special permit now?
Could the Lobisser apply for a new special permit?
Yes.
As long as the project was not identical within 2 years, a new permit could be applied for. If the application was not identical, or was identical, you'd wait 2 years and apply for a subsequent special permit. Well, practically speaking, Your Honor, I have not analyzed what potential changes there have been to the zoning bylaws since 1985, how they would apply, whether they would apply. My suspicion is that there is a discretionary element associated with a permit, and that the plaintiff, Lobisser, who I did not represent during the administrative process, made a determination that rather than suffer the risk of being subjected to a discretionary decision denying approval, that it would go forward on a special permit which was clearly activated pursuant to 48 Section 9 because construction commenced.
But if there are, at least hypothetically, new zoning bylaws and considerations that have come about in the intervening 20 years, wouldn't that be a public policy reason for not going your way because the special permit that you're trying to reactivate, or whatever you want to call, however you want to label it, it was granted at a time when conditions might have been very different. So why should the municipality be bound by that?
They won't be,
20 years later.
They may not be, Your Honor, quite frankly.
They can put it into a...
You're not arguing for a zoning freeze.
No. I mean, it will be what it is. The fact of the matter is, in connection with any development process, there are multiple stages of application and approval. What the court is presented with in this case is one component of that development process, and that is, was there a special permit in place, and was it activated pursuant to 48 Section 9? The additional consequences, which the planning board did not reach, which may ultimately be reached in connection with an application for a building permit, do not inform the court's decision and should not have in any way informed the land court's decision in this case.
Mr. Moriarty, let me ask you this. I mean, I think implicit in the beginning part of your last answer is that the board, that the board can put any conditions, any authorized conditions, including time within which the special permit can be issued, correct? It can be activated.
In connection with the original special permit?
Yes.
Yes. What the statute says, 48 Section 9, it cannot be greater than 2 years.
Right.
It can be less than 2 years. And in this case, town meeting, Bellingham adopted Section 1550 of the zoning bylaw, setting a 1-year lapse period.
Can it put a time within which the entire project must be completed?
In the plaintiff's position, absolutely. Is there an SJC case or even an appellate decision that specifically addresses what the first paragraph of 48 Section 9 means? No.
But from your point of view, you say, yes, they could.
Absolutely.
And that's not an issue here because they didn't do it here.
Absolutely.
You would say the Bernstein case sort of says that they can do that, but if they don't, then you're in your situation.
Yes, the Bernstein case one might suggest it was dicta on that point, but what the Bernstein case says is that so long as the permit is activated within the lapse period, if there is not a specific contrary provision in the special permit, it can continue to be constructed.
Sure.
The question there is whether Bernstein actually constituted a holding that the first paragraph of 48 Section 9, which references time, means a construction deadline. From the plaintiff's perspective, it does. And that is why the public policy mosaic is complete in this circumstance with regard to what the defendants characterize as warehousing permits. There is in Bernstein this notion that one should not warehouse a permit, and the specific reference in Bernstein is to the lapse period in 48 Section 9. What the Bernstein court says is you can't warehouse it forever. You have to comply with 48 Section 9. Once you do that, unless you have a construction deadline in the special permit, you get to continue with your project. So what the law allows from the plaintiff's perspective, clear in Section 48 Section 9, is two components to the durational analysis, or let's say two components to the time analysis, one being a commencement requirement and one being a durational component, so that if a municipality determines to issue a special permit and they want completion within a particular window, they have the power under the statute to do so.
Well, they said that they did that in this case. There's the annualized review essentially contemplated a 4-year build-out.
Right. What the defendants argue is that conditions 3 and 5 of the special permit can be read together to mean that there was an annual, that there was a requirement for specific conditions. It's there was a specific condition regarding a submission of annual phases.
Finish that.
What the special permit says is that no units in excess of a particular number cannot be submitted, or rather cannot be applied for and authorized by building permit prior to particular
but it
dates.
also says you have to submit an annualized, an annual review.
Yes. Well, that's paragraph 3. And what the defendants argue is you read 5 and 3 together, and you come to the conclusion that you had to do construction, a minimum amount of construction. But what that
and you couldn't do it all in 1 year.
But that's true.
Yeah, but that's why you read 3 and 5 together.
Well, yeah, you have to read 3 and 5 together.
So what's wrong with reading it the way they're reading it?
Because 5 does not set a minimum number. In no year did the developer have any obligation to submit a minimum number of units.
But you have 4 years.
No, that's not true. You can't build.
Well, you say it's not true. They say it is true.
Well,
what if we adopt their view? Does that end the case?
No, it doesn't.
Why not?
Because, quite frankly, the most direct reason is that the planning board didn't rely on condition 3 in denying the special permit. Within the scope of this court's review of the land court's decision, the land court was bound to the decisions that were articulated by the planning board in denying the permit. The planning board relied on lapse, Your Honor. Now, the defendants...
Mr. Moriarty, could I ask you a question? And I saw that you have talked about duration as the commencement and then construction completion.
Time as commencement and duration being a deadline for construction.
But you could have it that it's not construction completion. You could, I think, you could have that you have to commence a phase project within whatever to get the thing going, and then you have to, is it possible to contemplate that you have to get the last one going, the last phase going within a certain period of time? Or are you saying you can't do that
well,
because the statute would
I think the statute says time limitations, so that seems to be drafted fairly broadly. There is no case that provides any specificity with regard to how that would be employed in connection with a construction deadline. But from the plaintiff's perspective, that statute is drafted broadly enough to allow a municipality to say that and construction must be completed within, or construction of remaining buildings must be started by a particular time, that discretion would be available to a municipality. Of course, that is not contrary to the plaintiff's arguments in this case.
Would that be a lapse or a rescission?
Well, it would be neither, Your Honor. Lapse would still be controlled by 40A, Section 9. A rescission is a concept which the defendants attempt to import into special permits, which is wholly an opposite. The rescission concept would be where the underlying zoning authorization becomes invalid. The plaintiff's argument with regard to a durational time limitation, that is something that's absent in this case, but that if there were employed a construction deadline, that if the construction deadline were to expire, and although it's not immediately relevant to this case, the plaintiffs would perceive the construction that had been completed prior to the construction deadline as being valid, and so that the construction would not be able to continue after the expiration of a construction deadline. So the effect there would not be a rescission, meaning that the special permit would not be invalidated because there was a construction deadline. If construction was done within,
it essentially would blow up at a certain time.
it would stop the ability to
So
exercise.
there's nothing that would bar a town from saying, it can't say that you have 5 years before it lapses, because that's contrary to the statute, but it could say you have 5 years to complete Phase 2 and Phase 3 of your project.
Yes, Your Honor.
And if you don't get it done within that 5 years, the special permit essentially no longer is in effect.
Yes, with the result not being a rescission, such that the earlier phases are not undermined.
You have to stop.
You have to stop. But to get back to Justice Spinas' question with regard to this argument that there really is a time, that there is a construction deadline in this case, automatic rescission also factors into that analysis, because what the defendants are arguing is if there was a violation of Condition 3, somehow the special permit was invalidated, and that's not the case. They do rely, in fact, on a rescission case that comes out of the subdivision control law analysis. The reality is that a violation of a condition implicates a building commissioner or building inspectors, or warrants, let's say, a building inspector's attention under 40A Section 7, but that's an enforcement action. It doesn't invalidate the special permit.
The building inspector would go out and stop construction that was being conducted in violation of the permit.
Right, and that.
But in this case, as I remember the record, year one, your predecessor built 21 or 23, whatever it was, 21 units. Year two, they built 21 units.
20.
20. So year three, they ran into a septic problem, technical problem, and all construction stops. It appears as though from the conduct of the parties that it was contemplated that there be a 4-year build-out.
Well, to say that there was an intention that there'd be a 4-year build-out may be absolutely correct, Your Honor. There may have been an intention to build it out in 4 years. The best of intentions sometime, lay on the side of the road when there is an economic collapse. The question is, and it really is a technical question, did the special permit impose an obligation for this developer, for this applicant, to construct any minimum number of units in any particular year?
Mr.
You
Moriarty,
only have to read Condition 5 to answer that question, no, Your Honor.
Isn't a more fair reading of the Condition 5 that what the town was concerned about was building out the whole project too rapidly?
Not only fair, that is exactly what the paragraph says. There is no other reasonable.
For example, in year two, instead of building 20 units, they had built 45 units because the second year provided 42 units. What's the remedy that the town can go in and order a cease and desist, or the building commission, the building?
Well, it's two-step, and it brings us right back to paragraph 3 and what paragraph 3 actually does in that special permit. Paragraph 3 is no more than site plan approval. That's what in Bellingham development plan approval is called. It's no different than site plan approval. Condition 3 required the applicant to provide evidence to the board annually that it was not exceeding the threshold set by condition 5
Well,
in the special permit.
maybe. But let me get back to question 3. Let me take the other tact. What would have happened if you built 21 in year 1 and 20? Let's say you built 21 in year 2. Year 3, you come in and say, bad economic times, we only want to build 10. Year 4, you come in, bad economic times, worse economic times, we only want to build 5. Year 5, we come in. Now times are better, we want to build 21 this year.
Fine. Because paragraph 5 clearly sets deadlines in the cumulative. No more than 21 by January 1 of 87, I believe, is the first.
Yeah.
No more than 42, January 1, 88. No more than 63, January 1, 89. No more than 84, January 1, 1990. So you can build less, and you can certainly build more, so long as you are not in excess of the aggregate total. Never authorized, of course, to build more than the 84.
And I assume that if you've given permission for whatever the total number was there a total number?
84?
84.
84, that if prior to January 1, 1990, you haven't built 84, sometime after January 1, 1990, you can build whatever number. That's your position, right?
Absolutely, Your Honor. And it, with all due respect to the defendant's argument, what we are focusing on is the words that are actually stated in Condition 5 in clear and precise terms as a condition of that special permit.
Thank you, Mr. Moriarty. Good morning, Mr. Tallerman.
Good morning, Your Honors. May it please the Court, my name is Jay Tallerman. I'm Town Council in the town of Bellingham. This case does involve, and we didn't touch on the condominium issue too much before, and maybe we'll get into it later here, but the central issue is the interpretation of that 13th paragraph of 40A Section 9 regarding louds. What we know is that the town has adopted a bylaw, Section 1550, in accordance with the range of guidelines under that paragraph. And they've said you have a 12-month time to build something or start a use, or unless...
And they did that.
They did that. They did what they were allowed to do. They have that requirement.
And they did what they were allowed to do in year 2.
In terms
In
of
the second
the
year.
developer, yes.
Yeah. What if in the...
And year 3 and year 4.
No, they didn't.
No, they did not in
didn't.
year 3 and year 4.
Well, they did. They were not allowed to build more than by then, and they didn't.
They
correct?
were not allowed to build more than. We think the more reasonable reading
No, I understand.
is...
But they didn't build more than, correct?
No, they did not build more than. But in
Would it have been in violation of the permit for them to have come in year 3 and asked to build 10, come in year 4 and asked to build 10, and come in year 5 and asked to build 10? Could they have done that?
and build it out in a slower fashion than that?
Right.
In our opinion, no. There's an orderly...
What specifically in the language of paragraph 3 prevents them from doing that?
Because we argue, and the board's position is entitled to deference, as is the land court's interpretation of those same facts.
No, because that's a question of law.
Well, in terms of the interpretation of the specific language and what the town's reasonable interpretation is obviously entitled to deference under the zoning cases of their own enactment, to the extent there's an ambiguity under zoning. Now, the fairest reading, and in fact the reading that the developer, the plaintiff, agreed to below at the land court, was that this was a 5-year build-out.
Is there anything specifically in the record that says that is a condition of the permit?
Yes. In fact, the agreed statement of facts in the summary judgment proceedings here, which are at page 60, I believe, of the administrative record, and this was before the land court came up with their decision interpreting Bernstein in an expansive manner, which we feel is the correct manner, the plaintiff agreed this was a 5-year build-out. I represent cities and towns across the Commonwealth, and the reason, in response to Justice Spina's question, that a slower build-out is not a great idea is you don't want a half-built-out subdivision or condominium development. You don't want them to do it in little bits and pieces because people are living amid rubble. They worked on it.
That's the concern of the people who buy the condos.
It's the concern of the town, too. We have and I think this goes to the policy question that was raised earlier in Mr. Moriarty's argument, and that is that it's a home rule state. They have a home rule power to design things through permitting or through bylaws. Here in the permit, they looked at something, they agreed on a plan, they have an interest to protect those residents as well as the residents as a whole in the community by imposing certain requirements and conditions in a permit that will allow for an orderly build-out that will maintain health, safety, and welfare and result in an aesthetically pleasing condominium development.
Is that your response, Mr. Tallerman, to the argument that if we if we affirm the land court holding, then developers will be discouraged and large condominiums won't be encouraged?
I don't think so at all. I think that towns, and Bellingham has a tremendous amount of condominium developments, it's part of the zoning process and the permitting process to come in and say, this is how we propose it. Very often towns require phasing so that they're not hit with all the infrastructure immediately.
No question about that.
And
no question about that, and that's clearly what Bellingham did in this town.
That's
in
right.
This case.
So I don't think it's a discouragement to interpret this.
No, it's a discouragement if you say you've got to do it all within a certain period of time.
I don't
It
believe.
may be. I mean, that you can negotiate. That you can negotiate.
That's right. Well, I mean, it benefits both parties to have phases as well because building something out all at
It may
once.
or may not, but that's certainly a negotiable term. For example, it may not have benefited this particular developer to agree not to build more than, right? The town didn't want it to build more than.
The town didn't want it to build less than either. I mean, you can't
But it
read it
didn't
for
say
the
that.
proposition.
It
that-
didn't say that.
Right.
It said not more than, authorized not more than.
That's right. That was to protect them from having too much at once. But there was.
I understand. What I'm saying is that sometimes the interests overlap and sometimes they don't overlap.
That's right.
And I think I just heard Mr. Moriarty say the town can negotiate.
That's right.
How do you deal with the New Seabury case?
Then, in terms of the new Seabury,
It went on for years and 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 years.
well, again, the beauty is in the details here of the permit. Because you can fill the Chapter 48, Section 9, Paragraph 13 is somewhat silent on the issue of phased condominiums. And I think
So what language in this permit are you relying on?
I'm relying on paragraphs 3 and 5.
I'm reading, all right.
And again, as we've already noted, there was, and Mr. Moriarty concedes that there was a 5-year build-out plan. In fact, their prior papers concede that
Well, it
point as
depends
well.
what you mean by a 5-year build-out plan. A 5-year build-out plan may not be finished within 5 years. It may say we couldn't do it all in year one. I mean, I'll have to look at the stipulation, but it seems to me that that's not inconsistent with that.
Well,
they
then-
couldn't do it all in year one.
Then it would be incumbent upon them to come back to the planning board and say, as developers often do, and say, we need more time. I preside over extension proceedings for special permits all the time. It's a part of the process.
Could we go back to Justice Botsford's question? What specific language are you relying on in paragraph 3 and 5?
Well, I think reading those two provisions together, the first one, 3, requiring annual submissions, clearly corresponds. What's that?
Plans?
Yes. Annual submissions of plans clearly corresponds to the 4-year build-out.
Well, except that you could say, this year we don't plan on building any.
Okay, then it would have been incumbent upon them when they came in to seek an amendment of that schedule.
Why?
But why? They could have built 21 the first year, 21 the second year, none the third year, and 42 the fourth year.
And then what would have happened if they didn't to build it all at once was viewed, again, not in an orderly way that would allow the town to keep pace with its infrastructure. Allowing an equal amount or roughly equal amount every year was to the town's benefit to do them all at once.
Yeah, but taking Justice Spina's hypothetical, they would then not have been required to submit plans under paragraph 3 in year 3. They built 21 in year 1, 21 in year 2,
20 in year
20 in year 2, nothing in year 3.
That would have, in and of itself, been a violation of the permit. And the land court discussed this, too. The appellant's arguments in their brief say that the land court did not discuss this, but the land court did discuss quite clearly that it is on its face a violation not to have submitted a plan in year 3, and they did not do that. Now, what would have happened, and this follows up with something that was discussed earlier, in terms of enforcement. I agree, there's no automatic rescission under zoning. But when they would have come in for a building permit, the building inspector could have denied it because every building permit, as a matter of law, has to comply with zoning. And if in reading the permit he says, you want to do 42 at once,
Mr.
you can't
Moriarty
do that.
says, fine, let's go duke that out when we get to that phase.
But they didn't get to that phase.
Well, he's saying because it's premature. You know, when I go apply for a building permit, then I'll deal with what I have to deal with from the building inspector.
And we might be before the court in a different posture on that.
Well, it might be, but he says that doesn't affect the special permit.
Could the board have taken some action to vacate the special permit after 2 years ended and there had been no work?
Yes, what could have happened in terms of the orderly zoning process is the board itself, as the master of its permit, or any other municipal authority, or any person in the town even, could have requested enforcement against them in some way, shape, or form through 48 Section 7. The building inspector has to make a determination. Let's say the building inspector makes a determination, yes, they're out of time. An order would ensue saying no further development. The developer could then appeal that if they wanted to. It's discretionary. They didn't do it here. It was lying fallow. Towns generally are not particularly upset when things don't get built, as the case is. And at that point, they would go to a zoning board of appeals, if it was appealed, and then to the Superior or Land Court.
If the town didn't commence it in a reasonable time, why should it have the right to do so now? Could the town wait for 20 years and then just come in and say, oops, by the way, you didn't comply with year 3?
Well, there are reasonable limitations on enforcement actions in terms of permits for construction. So you only have a certain amount of time for enforcement under Section 7. But that doesn't mean that you're complying with the permit.
The question was, could they have come in if there were no plans submitted in year 3 to come in and say you violated the terms of the agreement and so you can't go further, you can't go forward with anything else?
They could have,
They didn't.
but it's discretionary. There's no requirement that they do that.
No, of course not, but don't they then waive any claim that that was a violation?
Not at all. There is no case under law that says a town ever waives the right to enforce the terms of its permit. The fact that the use elements of the permit are in effect guiding the method of construction under that permit. So when someone tries to pull a building permit and the building inspector reasonably determines that they're in violation, it is still a violation. There is not a mandate that they do anything. There's no mandamus on that type of issue.
Did you argue before the board that the plaintiffs were in violation or their predecessors were in violation of paragraph 3?
Well, I became town council just this past September.
Now,
I
what's the
wasn't
answer?
part of those
What's the answer?
proceedings.
Did you argue, was it argued or not?
I don't, in terms of paragraph 3,
Right, yeah.
the decision itself
I know the decision
doesn't indicate it.
does.
It talks about lapse. I do not know the answer to that question regarding paragraph 3, but this raises an important point that I wanted to address
You haven't
briefly.
looked at the memoranda that were filed in the land court?
I have looked
And
at.
was it raised? Was a violation of Section 3 raised there?
It is raised by the land court. Most assuredly, it's raised by the land court in multiple provisions, violations of paragraph 3. They ultimately relied more on substantial use questions.
No, I understand. I said,
But they
did you
reference
raise
that.
it?
Now, it is important to note, and in contrary to the interpretation raised by my brother, that the land court conducts a de novo review. A denial of a permit doesn't have to say much. There is case law on that. The land court then conducts a de novo review, finds all the facts anew, and they can either uphold, while still providing adequate deference to the local hearing agency, they can either uphold or not uphold based on any facts that they find. They can't supersede, substitute their own judgment as to a local issue of public health.
It's really a question of law. I mean, the land court's decision is based on an interpretation that it had lapsed because there was no building after 92.
Yes, I don't disagree with that at all, that there is a large question of law here. But if the question is, as my brothers raised it, can the land court look at facts that the zoning board may not have considered in applying the law to this particular condominium development, then absolutely they can. That's what the de novo standard is.
Can the land court raise sua sponte legal arguments that the board hasn't raised?
Well, the board did talk about lapse. The board doesn't say what type of lapse. Was it lapse because of a violation of Section 3, or was it a lapse because of lack of substantial use? but they said left.
The board does state, as the decision of the board stated, quote, "Plans shall be submitted in annual phases," decision paragraph 3. So the land court does address that. Then it says, further, the decision limits the units that can be constructed in a given year.
Yeah, and we think the fairest reading, and certainly the board's interpretation of that, is that they have to be read together to talk about the 5-year build-out, which again,
Mr.
previously...
Tallerman, I don't want to beat a dead horse. May the land court rely on legal arguments that were not raised by the board? Legal arguments.
Yes.
And the authority for that is?
And legal arguments at the summary, in what, I want to understand the context clearly. Can they rely on legal arguments not raised by the board below during the local hearing?
No, before it.
Yes. They're interpreting the law as they see fit. First of all, both parties raised Bernstein.
So there's no theory of waiver in the land court?
Not a waiver of arguments. First of all, both parties raised the legal arguments that are before you, the Bernstein argument.
Did the board raise the paragraph 3 argument?
Did the board's motion raise the paragraph? I don't recall offhand. But again, a de novo review of that fact in applying the law that the parties raised, I think, is an acceptable premise of de novo review under land court proceedings.
Counsel, let me ask a question. There are 2 amici in this case.
Right.
Well, there's more than 2, but 2 that raise the following concern, that the land court's ruling, if permitted to stand, would undermine the zoning legitimacy of thousands of condominiums in Massachusetts that were constructed through phased construction. Both raise the concern. It is a concern. What's your response to that? No?
No. My response to that is that's not true. And I think the vernacular response to that would be the devil's in the details. Nothing about those concerns cannot be resolved through working with the zoning board to establish a process or to modify that process through a modified special permit.
I'm talking about it. They're talking about existing units constructed pursuant to a phased development plan. The zoning literally would, if we follow to conclusion the land court's decision, they would have been built in violation of the zoning laws. Because they would have been built in violation of the special permit. You would have had to have examined, you have to examine in each case whether such things as project infrastructure or other elements. It's a factual inquiry that the land court set up and that Bernstein sets up to say, if you are going to try and revive phases 3, 4, 5, 10, whatever, and you had installed the road or installed some septic work or some utilities, poured some foundation, did something.
But the concern, I think, is maybe a different kind of gravity. Those buildings may have to be torn down.
No, well, there's a limit on that. And that is a fundamental limit on the statute of limitations under zoning. First of all, those had to get building permits to begin with. So the certification that they complied with that permit is in and of itself a certification that they comply with zoning. Someone can always challenge that within the 6 or 10 year statutes of limitations under Section 7 of Chapter 40A. But once that statute of limitations passes, and no different for condos or single-family houses or office buildings.
Isn't the easier answer just that if the board wants to have a limit, they put it in, a durational limit?
And we feel that was done. Could boards be more artful?
Mr. Tallerman, I take it from your answer that if we disagree with the land court's legal interpretation of the agreement, it's the end of the case.
It depends on how much you disagree, because we feel that there's a de facto violation as well as the Bernstein analysis. They failed to submit the annual phase plans, as well as failing to make substantial use. It is not necessarily the end of the case, and I wanted to correct something for the record here. This was, to answer a question before, a special permit for a modification here. This was a discretionary permit. So to get back to those facts, and all you have to do is look at the application that's in the record, which I believe is on page 152. So the board denied for 2 reasons. One, they didn't give enough information on the modification of the plan. This would then go, if you disagreed with the land court, this would have to go all the way back to the board to have a hearing on the discretionary permit modification.
So from your perspective, you think that there was a limit, and the limit was perhaps not stated as well as it might have been, but if you read paragraphs 3 and 5, it gives you your 5 years.
Yes, and that's already been previously agreed by the parties. The appellant does not agree anymore with the statement he made earlier, but
Mr. Tallerman, let me ask you this. There has been a decision on the modification request.
that is correct.
Did the planning board make any findings that the revised final plan or the entire project failed to satisfy any use, dimensional, parking, or other requirements of the zoning bylaw?
No, they made a determination that there was insufficient information submitted.
Okay. Thank you, Mr. Tallerman.
Thank you.